we said that this last session would be why we must act now. It probably ought to be thought as much to be a question of what we ought to do. And much of that has already been addressed. There are ways in which we can simply look more strictly at the legislation, seek to enforce some of the intrinsic restrictions that limit the harm that can be done, that are already present in the legislation. It may be that we can foster clearer interpretation of the legislation. But there's an example of that that's transpiring presently in the state of Minnesota. A recent custody case has come up for review, reached the court and produced an opinion that greatly narrows the application of the ICWA. That's subject to appeal at the federal level, but for the time being greatly narrows the application of it. I want to share with you, just as headlines, the three principles that come out of that decision. The plain language of Section 25, etc., ICWA is not ambiguous, and with respect to an Indian child not residing or domiciled within the child's tribe's reservation, permits transfer to tribal court of only foster care placement and termination of parental rights proceedings. The provision of the 2007 Tribal State Agreement requiring transfer of any child placement custody proceedings is void to the extent that it purports to require transfer of pre-adoptive and adoptive placement proceedings involving an Indian child not residing or domiciled on the reservation of the child's tribe. And finally, with respect to an Indian child not residing or domiciled in the child's tribe's reservation, Rule 48 of the Minnesota Rule of Juvenile Protection Procedure, providing for transfer of the juvenile protection matter to the tribal court of an Indian child's tribe, is limited to foster care placement and termination of parental rights proceedings. Now, that's an instant decision just made within the last few days, so to speak. And that decision means, of course, that it has far less extent, ICWA does, than it is often claimed to have and as it is often applied. So if this decision is upheld, you would say, we're on the road to recovery. Now, it doesn't mean there aren't still problems. Even if we limit this transfer from state to tribal jurisdiction to foster care placement and parental rights proceedings, there is still large scope for abuse, some of which has been documented. The last time I was present in this chamber, I did not introduce myself at the beginning for good reasons. I'm notorious. But my name is William Allen, for those of you who do not know me. And I was last here some 22 years ago, appearing before the Senate Committee on Indian Affairs. I sat on the opposite side of that table as the committee members sat at the dais. And they were concerned to have me justify my intrusion upon the tribe at the White Mountain Apache Indian Reservation when I went to inquire into the status of an Indian child who had been removed from the care of adoptive parents and taken back to the reservation at the age of 12, and who at this time was 14 years of age. And I had carried out my investigation. It was purely an investigation, not an enforcement, in such a manner that it fostered sufficient fear, suspicion, and ill will that what followed as I sought to leave the reservation was an arrest on a spurious charge of kidnapping in the middle of the Arizona highway. So it was a matter of high controversy in the country, received broad national discussion, and a great deal of time and endless pages of congressional record were devoted to recording it. As I sat here in an exchange with Senator Inouye, among other things, I described our Indian policy in this country as a form of apartheid, that we were systematically enforcing apartheid in the United States. Senator Inouye asked me, do you really mean that? To which I responded, yes, and asked him, would you care for me to expand? He said, no, that's all right, let's go on. But I will expand. I will tell you that something is fundamentally wrong when the policy cannot be implemented without being based at its heart, most fundamentally, on a prior determination of racial qualification. A supposed policy, benign in its intent, becomes malign in its effect when it has to be implemented based on the prior determination of race, ethnicity, or national origin. It's as simple as that. And that is, of course, all that apartheid does. So it's not difficult to expand on it, but I'm not sure Senator Inouye would like to hear, even today, that expansion. But we need to hear it. We need to be adverted that there is no such thing as a Native American. We say it so casually, so easily. But I'm really pleased and proud that the museum is identified as the Museum of the American Indian. I recall when I've spent some time at the annual conference in Albuquerque of our Indian Tribal Association, and I shared with them my sense that there was something peculiar, most peculiar, in a people who were proud of their distinct heritage and tradition, calling themselves by a name that was attributed to them, not one that they assigned to themselves, but attributed to them by outsiders, essentially by white anthropologists in the 1930s, 40s, and thereafter. And that became the prevailing terminology, which defined their culture. How much of an intrinsic culture is a culture that somebody else has named? Not very much, but you say, well, what about the name Indian? Didn't Columbus give them that? Yes, as I explained to them at the time, but that was merely an accident. All that describes is the fact that Columbus didn't know where he was. That causes nobody any problem. There's nothing pejorative in it. Better to be called an Indian in that sense, the result of an accident, than to have your name imposed upon you by someone who's not conversant with who you are or what you place your priorities upon. There are no Native Americans. It's also true there's something fundamentally flawed with this population that we identify as the Indian population, which seems to grow and contract as the decades roll by with the changes in federal policy. The more generous the policy, the greater the numbers. The less generous the policy, the fewer are the numbers. Which is, of course, testimony to the fact of the extraordinary degree to which there has been broad assimilation of Indians, as originally understood, into the society of the United States. I could tell stories personally known to me of people who spent entire lifetimes fully living within this society as white or black or whatever, it happens all across the spectrum, who are almost entirely Indian by heritage, who were not moved to identify, to return to the reservation. Something artificial about this conversation. And therefore there's something artificial about the Indian Child Welfare Act. We are pretending officially and formally by act of Congress. You see, there's not only the legislation, there are the so-called legislative findings, which is the way Congress pretends to know what it's talking about. And it uses spurious scientific evidence, often as not, to say, we're going to do what we want to do. If you want a justification, we'll give you one, and we don't care whether it pans out upon investigation or not. But the fact of the matter is there's something spurious about that process when it asks us to deny the evidence of common sense. We can see the world around us. We should never accept any command to close our eyes to it. Of course, we must participate in legal processes through legal forms. Therefore, we must bow appropriately to all of the demanded terms of reference that the law imposes upon us. That doesn't mean we have to believe them. It doesn't mean we have to accept them in our forming our own judgments. It means only that we have to be clever in the way in which we address the law and seek to reform them. This, therefore, is what is at stake in talking about this particular case. I mentioned the Choctaw case earlier this morning, the Holyfield case. One of the observations that must be at the center of our attention derives from that case. After everything else was considered, all things being equal, everything said, the court made this observation, which is absolutely critical, namely that it was faced with a dilemma to recognize the individual liberty of the parents or the prior claim of the tribe The court said to recognize individual liberty, the court would have to nullify the purpose the ICWA was intended to accomplish. Those are the words of the court. That the only way it could give recognition to the claim of individual liberty was to nullify ICWA in terms of its intended purpose, not just its letter, but the purpose it was intended to accomplish. Now, given that language, in the primary decision establishing the constitutionality of ICWA, I believe we see what our task is. If anything Congress has done has a purpose antithetical to the defense of liberty, it is on its face wrong. It's as simple as that. On its face wrong. And therefore we must find a way to set it right. And how much greater is the obligation to act to set things right when doing so rescues the innocent from needless suffering? That is our task. That is our task. That is why we must act. That is how we must act. We must petition for change. Yes, it's been 20 years and more. It may yet be 20 years again, who knows? But one thing that we do know is that we have the ability to speak. We can raise our voices. We can petition. We can insist that people do not close their eyes to the abuses that persist among us. That's what the presentation today has presented for us. I was explaining earlier what happened in that case 20 years ago. In a way, encapsulates all that we experience now. After the phony arrest and all the controversy, I did not abandon the case of Lolita Altaha, which was her Apache name, Derosha, her adopted name, but rather continued to interact with them covertly. She was ultimately freed by the tribe, returned to the parents who had adopted her, with whom she had been placed by the birth mother originally, incidentally. A familiar story as we know. We continue to correspond, we still do to this day, quite regularly. I would be embarrassed to read to you the kinds of tributes she addressed to me subsequently. But the point is, she was released. She was released. She went back. She led a good and healthy life, was able to finish school, finish college, and become a professional librarian, and is living in Arizona and taking care of herself. But to get that result, I had to agree with the tribe that none of us involved in it would ever utter a word about it before she turned 18. That we had to maintain absolute secrecy until Lolita was 18. I did so because I was concerned about her leaving. But that rule of secrecy is what also ties our tongue about the policy at large. As we suspect that we owe something based on past abuses or lingering guilt for the suffering suffered by Indians in general, that we owe to bow to their cultural claims, that we owe to bow to vague and mysterious notions of heritage, some deference that silences us in the face of these abuses. Well, my vow of secrecy was limited. It was only until she turned 18, and I've spoken freely about it since then. And I would say there's a timeline on that sense of guilt, too. There's a timeline that should tell us we don't have to keep our tongues tied out of deference. And the best way to understand that timeline is to ask yourself a simple question. How much do you care about your fellow citizens? And once you've answered that question, ask yourself this question. Do you acknowledge that the Indian is your fellow citizen? And if you answer both those questions in the way that I do, you will act, and you will act now. Thank you so much for joining me.